So welcome to today's webinar. I'm Carly Hansen from Community Legal Centres Queensland, and today's session is on the National Data Consistency Project that NACLC have been working on for the last year and a bit. So NACLC have been developing a data consistency guide with CLCs and family violence prevention legal services across Australia. The aim of the guide is to help centres understand the service types that underpin CLASS, which is the database that most of us use, as well as government reporting requirements. So today we've got Polly Porteous from NACLC here, or in Sydney actually, but joining us today, and she'll talk us through the main service types as well as where NACLC has landed on some of the big controversies in this area. Polly will then open up discussion about some of the more tricky areas. I know that you've all got questions, so we'll take those questions at the end of the session just so we can keep to time today. So I'd also like to acknowledge the traditional owners of the land on which we're holding this webinar. In Brisbane, they're the Turrbal and the Yagara peoples. I wish to pay my respect to their elders past, present and future, and acknowledge the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. So today, as this webinar is being viewed by people throughout the country, because the data standards work is national, I'd also like to pay respect to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians listening today. So today's webinar is being recorded, and I'll pop the recording up on our website later and send the link out to you all just in case you miss it. We did have a very high number of registrations, so it's all looking fine so far. I haven't had any notifications to say people haven't been able to log in, which is great, but just in case you do have any dramas, you can catch the recording. I've also emailed out Polly's PowerPoints, or a link to those PowerPoints on our website, and they're also uploaded into the handout section of the GoToWebinar control panel, so you can download those. Lastly, if you would like to ask questions, and if you think of questions as we go through the webinar today, just type them into the question box on the GoToWebinar control panel, and we'll read those out for Polly to respond to at the end of the session. So now I might hand over to Polly in Sydney. Thanks, Polly. Take it away.
Thanks very much, Carly, and thank you all for joining the webinar today. So my name's Polly. I know lots of you. If not, you'll get to know me during this webinar. So again, I'd also like to pay my respects to traditional owners of the land on which I'm gathered, the Gadigal people of the Eora Nation, and this is where the National Association office is, but also pay respect to the people across Australia, and I pay deep respect to elders past, present and emerging, and to any and all Aboriginal people attending this webinar. The webinar housekeeping Carly has already run through, so I won't spend too much time on that. Let's get into the guts of it. Okay, so the aim of the webinar is to inform and update community legal centres and family violence prevention legal services about the National Data Consistency Project. And as Carly said, it's also to talk through some of the main areas of controversy or inconsistency and the feedback we received when we consulted on the draft Data Consistency Guide earlier this year. We're also going to outline the proposed changes to some of the main service types and to tell you about the resources that we're developing and will make available very shortly, and just to say what's coming up next. There is quite a lot of information in this these overheads, and I will move through without speaking too fast, but I'm sure Carly will let me know if you guys are complaining about me moving too fast. Holding questions to the end would be great. So let's have a bit of a look at the Data Consistency Project. Hopefully lots of you are aware of it, but basically we started this in July 2018. We received a little bit of funding from Commonwealth Attorney General's Department, but also from Legal Aid New South Wales. The purpose was to make sure that the data being collected by CLCs and family violence prevention legal services was accurate and consistent, so that you can know that how data is being recorded in one centre is the same as how data is being recorded in another centre. And that means that you have good data that can inform service planning and service provision decisions for the centres themselves, but also that the state, territory, national governments have reliable data to use for NPA reporting and also for service planning. It was a joint project, so Kylie at CLCQ was very much part of the project with me. She actually had moved through a lot of the issues and had some early insight into what the issues were being faced by Queensland community legal centres. So we joined forces and included Kieran from Victorian Federation of Community Legal Centres, who was also doing a similar project. Sorry. This is a very busy project timeline, which I won't talk through in too much detail. We'll come back to at the end, but it sets out where we've been, what we've done. The consultation phase, which was last year, over 40 community legal centres and family violence prevention legal services were consulted one-on-one to identify how they're recording data and see if we can come up with what the main issues were. We had a workshop at National Conference. We did some internal work. We also provided feedback to the Data Standards Working Group, which is the National Legal Assistance Data Standards Working Group. And we then put out in March the National Data Consistency Guide as a draft, and then sought your feedback on that guide. We are now at the point of finalising the guide, preparing training and other resources, and then I'll talk through when we get to the end of the presentation what's coming up next. Before we get into the guts of it, I just want to take a step back and talk about why this project is important. The fact that you're attending this webinar means you guys know why it's important. But what we wanted to do is make sure that the data that community legal centres and family violence legal services and Aboriginal legal services is recording is accurate reflection of what's happening on the ground. And we want to know this because we want to understand the different models of service provision. So do some types of centres have different ways of providing services than other types? Are they doing generally more legal advice, or are they doing representation? Is there a lot of help with people who are self-represented? Is there a lot of duty lawyer work happening across the country? Are some states doing more of a particular type of service than others? And the funding bodies wanted to know, just as a big picture, what kind of things and what are the trends happening over time. And the peak bodies, the state peak bodies and NACLC as the national peak, also wanted to be able to interrogate the data and know that it was an accurate reflection of what's happening on the ground. One of the big issues was, we'll talk through some, this next few graphs are a way of showing you how we can use class data, in this case, to look at what is happening on the ground at a, without going into details, obviously, centre by centre. But for example, if you have a look at this, this presentation here, this graph, what this tells us, me because I know it intimately, is that you have legal tasks starting to appear in the period from January to June 2017. Up until that point in time, there doesn't appear to be any legal tasks being undertaken by community legal centres or anyone using CLASS, and that's because the concept of legal task only came in when CLASS itself was rolled out as a database. Up until you'll see that big sliver of yellow for January to June 2017, Celsus data was what was brought into CLASS, and that's what you'll see reflected there. Celsus did not have legal task, so obviously you wouldn't expect to see legal task in those earlier periods. What you see over time then is that there is still a huge amount of legal advice, so proportionally most of the work that community legal centres and family violence legal services are doing is legal advice. Then you'll see a slab of about 10% of legal task and 10% of duty lawyer, and then the rest is court tribunal representation or other representation. This is the thing that really blew my mind when we first looked at this. So if we wanted to say whether or not there was a difference in service delivery in different states or territories, we would look at this and say there is. So what this looks like is, for example, Queensland. 70% of all services delivered by community legal centres and service providers using CLASS in Queensland is legal advice. Then you've got about 12% of all services is legal task. Then you've got about the same for duty lawyer, a little bit of court tribunal, a little bit of other rep, as compared to Victoria, where 60% is legal advice, and then you've got a little bit of legal task, a huge amount comparatively to other states of duty lawyer, a little bit of court tribunal, and quite a lot of other representation. Now, our concern when we looked at this graph was we wanted to make sure that this is actually what is happening on the ground. Can we say with any certainty that in Queensland, the centres are doing 70%, on average 70% legal advice? Or have we actually got differences in each state and territory as to how the centres are interpreting certain things? So, for example, is in South Australia, have they decided that they're not going to record legal tasks? Is that why it's so small? Or is it because they actually aren't doing legal tasks? Have they decided that they're just going to put in as many matters as possible into other representation? Who knows? If we know that all the centres are interpreting service types the same, we can look at this with some degree of certainty and analyse it. The next graph is very busy. It's just a snapshot of in one state. Here's 30 centres. I don't think it was all the centres. Sorry, it was all the centres. Look at the variety of the different proportion of service delivery occurring in each centre. Are we satisfied that this is accurate, or is it because, say, Centre 15 has decided they're only going to record legal advice and other rep, no matter what they're actually doing on the ground interacting, they're just going to chuck everything into either one of those or the other. Hard to tell. I suspect that over the years we'll start to see this even out a little bit more. So that's just an example of why it's important that we have faith in what the data is that's being entered into the system so that we can analyse it and understand what's actually happening out there. So in the data consistency project, after talking to lots of community legal centres, we figured out there were 5 solutions that are going to improve consistency. So one is to have a source of truth, the data consistency guide. That's the online, where it is online. It cross-refers to class documentation. The current version that's up is the old version. It's about to be updated with all the revisions that have come out after the consultation and feedback during March to May. And that will be the place that class help desk, funding providers, everyone will want to point you to if you have some questions about how to define a service. Changes to class, so we realised that there actually needs to be some changes, and we'll talk through what those changes are as we go through the presentation. Class training and help desk, we need to provide training on the data, data consistency, on the definitions of service types, and we need to do this through the regular class training schedule and also one-on-one help via help desk. So any tricky case studies or scenarios, there'll be support available. National data standards, as you'll see when we work through, there's some new data definitions, new service types that we're putting forward to the National Data Standards Working Group, and some other work sort of refining some of the definitions. And finally, the risk management guide. So that needs to work in perfect sync with the data consistency guide so that the legal practice, their definitions for certain service types are consistent across the data consistency guide and the risk management guide. Just quickly, the data consistency guide consultation process, we put the draft guide out in March 2019. And we asked a whole lot of questions, and we got about 30 responses via both the survey, direct emails and phone conversations. Okay, so that was the process. Now we're into, and what have we got now? You'll remember this is the overview, the groupings of services that was originally in the Data Standards Manual, and I've brought it in just because I know lots of people have them up on their wall just to get their head around it. Changes that you'll see when you compare this to Data Standards Manual is that duty lawyer service, we've accurately, I think people gave us feedback that that's really a discrete service. It's a discrete unbundled piece of work. Ongoing services, you'll see a brand new service down the bottom there, ongoing legal support service, and we'll talk that through. On the next page, we have the community projects, and you'll see that at the moment, how this looks now is how we'd like it to look in class as well. We've got feedback about the ability, people want to be able to have community education resource, community education activity as separate service types, and we think something similar needs to happen with law and legal service reform. Sorry, I'll just go backwards a little bit. So the Family Violence Prevention Legal Services have a category of service provision under their funding agreements, which is early intervention and prevention. We think we need to work with Family Violence Prevention Legal Services to step that out a little bit more and make sure that we have service types that accurately record that work. Okay, so I'm going to just touch briefly on a few areas that based on the feedback, we've changed in the data consistency guide, but mostly it's a clarification and it's better language or it's some clearer case studies. It's not major kind of rethinks. This is something, I'll work through these just off this overhead, and if you have questions, you can hold them to the end. So discrete services, one of the ideas we had was to have a very clear definition of discrete, and in the data consistency guide put forward that it might be based on how long the work took, for example in one day, or it's time limited. Got very definitive pushback from a lot of people saying that's actually more confusing, because the fact is some work is going to cross over from one day to another simply because you might pick it up at 4, and it seems ridiculous to say that it's not discrete because you have to finish the work the next day. And that was an area that people were really clear on. They wanted it defined according to a piece of work or an output. And when we get to the key issues, we're going to be talking about legal tasks, and I will talk you through what that means and how it works. Information service, so a few queries, and we're clarifying that the information service requires a direct interaction between a centre and a service user, so not chatbots or downloading resources from websites, and not leaving a bunch of pamphlets on a fair stall and then at the end counting how many have been taken. It has to be a direct interaction between a person from a centre and a service user. Referrals, so referrals in class are, you can put a referral destination in all services, and clarifying to people at the moment that is getting picked up as the total referral count in your reporting to funding bodies, and we need to have a conversation with the funding bodies just telling them that's the case, and if people would prefer that not to happen, then we need to make changes at the back end of the reporting for that. Reasons for referrals, people were asked, do you like I provided a table that set out when you use particular reasons for referrals, and got a bit of feedback. Some of that information was useful, some of it needs to be rethought, so there will be some clarification of the reasons for referrals, and I think there is a separate piece of work to talk through why collecting reasons for referrals can be useful, because a few centres said don't understand why we need to go to all this effort of recording reasons for referrals, particularly as the bulk referral insert tool in class doesn't allow us to do that. So you'll see some information in the data consistency guide when it's the revised version's up. Duty lawyer, so some questions about if it's a non-legal court support worker who's coming along either as a friend of a court but not in a legal role but is sitting with a client, is that a duty lawyer or a duty advocate scheme? And the answer is no, it's not. And a bit more detail will be in the guide about just being clear of the difference between duty lawyer and a court support role. Non-legal support, so a bit of discussion came back about if a staff member is a non-lawyer, does that automatically mean it's always non-legal support, or can a non-lawyer actually do a piece of work which would be covered under legal task? And a common example is when you have some work delegated by a solicitor to a paralegal, or you have routinely, you'll have a court support worker might help someone fill out an apprehended domestic violence order application form, and I would say that is a legal task, and again we'll step that out in more detail, and you'll see how lots of this stuff crosses over into legal practice management. It's not all about data definitions, it's often about on the ground, is this a legal transaction or is it a non-legal piece of work? So there is going to be some tick-tacking, I think, with the National PAI group on some of this when we're revising the risk management guide. And finally, community projects, general consensus, it does need more work. It never was properly scoped out, and particularly the Family Violence Prevention Legal Services, who are doing a lot of community projects, have called for some close consultation to help develop that out. Okay, just checking in on my time, and I wanted to be at 1:20, I wanted to be ready for key issues. So I'm sorry, I hope I'm not going too fast. I'm going to slow down a little bit. Okay, so this is the overview of the 6 main key issues that I'm going to talk through now. So I'll just start going through them. The first is ongoing legal support. Okay, This is not going to come as a surprise. It's the big issue that came up in conversations with lots of people. The problem that was identified during our consultations last year was that the National Data Standard says if you're not acting for a client and you're not representing, so if you're not representing a client or acting for them, then you need to record multiple legal advices or tasks for that person. So if they're self-represented going through a legal process, then it's not a representation service because you're not acting for them, and so then you have to record all these separate, discrete legal advices or legal tasks. This was an issue before the national data standards, we didn't have this need to analyse the relationship between a client and solicitor. It just wasn't part of how we recorded matters in Celsius, the old database. In practice, a legal practice would have one file containing file notes and advice sheets, and they would bring them all together if it was about the same legal problem. So the other thing is that in class it was a bit harder to see what was happening with a client when there's a whole lot of multiple discrete services around the same legal issue. As a result of both class and the national data standards, there's a range of ways centres are recording these kind of interactions. So a lot of centres are doing multiple legal advices and legal tasks and getting driven crazy by that because it's a lot of work. Some centres just open one legal task and they have lots of multiple actions over a long period of time, like months and months. Others just went through their hands in the air, which I totally understand, and said, I'm just going to open an other representation service and record all of my work under that service. And I'm indebted to Women's Legal Service Queensland, to Rachel, if she's on the line, who said, you know, that's what a lot of us are doing, because in the old days we'd call it a case, and we just want to be able to record the interactions and not have to create new services each time, because we have an ongoing relationship with this client right up front. We've said that. And we're recording these interactions, and just because we're not acting for them doesn't mean we're not doing ongoing work. So when we put out we put out a draft definition of ongoing legal support service and sought feedback from the sector about what they thought. About 2/3 of the centres who provided feedback said they want a brand new service, a standalone service called ongoing legal support service. The second most popular option was to redefine other representation service so that it became other representation and ongoing legal services, but then ideally to then categorise between where you're actually acting for them, a representation service, and where you're not acting for them. A few centres said, just keep it as it is, I'm happy. And those centres one of them just said, I just stopped changing things. I totally am sympathetic for that. The other one said, actually, we don't do that model of service provision. We either provide legal advice or representation service, but we don't do ongoing support to people who are going through self-representation. So the solution that we have come up with and that we think is going to make things easier for centres in the long run is to create a new standalone service type called ongoing legal support service, and that's the definition there. So in an ongoing legal support service, a centre makes an upfront commitment to a client to provide them with ongoing support in their own efforts to resolve a legal matter. The centre does not act for or represent the client and does not take carriage of the legal matter. Any communications by the centre with the client or with third parties about the legal matter make it clear that the centre is not representing the client. So the Data Consistency Guide provides a lot more detail, and we'll actually talk through this and break it down and talk about the importance of the scope, the upfront scope of services. And all the information in there and case studies have come from centres a lot of whom I'm indebted to, because they really had their heads around it and were quite clear about how useful this would be. So when the Data Consistency Guide is revised, you can read through and it provides quite a few different ways of figuring out if a particular interaction is a commitment to provide ongoing support. It also needs to be picked up in the risk management guide, and I want to liaise with NACLC will need to liaise with the National PII network to talk through making it clear about what centres need to set out the scope of services. Now, we're suggesting that from the 1st of August 2019, centres are encouraged to use the new service type, but actually this is a discussion that I think states need to have together. So I talked to Carly, for example, this week, and in Queensland, she is CLCQ is going to talk to Legal Aid Queensland about whether centres should be moving to a new service type now or should wait until your new funding cycle starts in the future. So probably the best advice right now is to sort of we'll talk to state peaks and see whether or not centres want to start moving to the new service type. The important thing to know is at the moment, although there'll be a new service type available, the ongoing legal support service will be available, and that's from 1st of August, it will map, in the short term, it's going to map back up to other representation. So this is because the NPA requires reporting against certain categories and this one's not in there. And so we're still in the same NPA. So the reports will bring that information into other representation. So we're going to National Data Standards Working Group. We've already submitted to the National Data Standards Working Group that we want to create this new service. If they recognise that the new service is one that all legal assistance providers want to use, then over a period of time, they will also support having the new service. But even if they never agree that it's a type of service that they run with, so for example, legal aid commissions often don't do this kind of work, then we can still have it at a class level. And then the important thing is to make sure it maps back up to one of the recognised categories in the Data Standards Manual, and that's just because of the NPA funding requirements. So I'm moving on from that. I know that you've all got questions. So I guess for now, I'll just say that hold your questions. So I'm happy to answer questions at the end, and I'll move through so that we've got time at the end. Okay. So the next one is secondary consultations. So we asked centres, how are you recording your secondary consultations and how would you like to record them? Some centres are recording them as legal advices with the client being the organisation, some recording as information service, and some have a separate spreadsheet because they're frustrated with class not recording it. So the feedback we got was really strong that it's actually, in terms of legal practice management, it's really an information service that that should, and in class, it'd be great if there was a way of accurately capturing and identifying that this is an information service, but it's also a secondary consultation. So there were some centres who suggested we have a standalone new service called secondary consultation, but quite a few said just leave it as an information service, but allow some additional fields that allow us, including agency details for the agency you're working with, and some sort of checkbox so that we know it's secondary consultation. So we are looking at that. And hopefully we'll be able to find that, we'll be able to make that available pretty shortly. So the other, the next issue, key issue 3, so this is the big one, a lot of people were interested in. So where you provide one legal advice, but you have multiple other parties, that's the main issue. But also if you have legal advice with the same other party, but it crosses into civil, criminal, family law, some centres have been recording that as, say, 3 different legal advices because of the issue with conflict of interest and making it clear that a particular other party belongs to a particular legal problem type. So you're not accidentally conflicting out people down the track. The other issue that a Queensland Community Legal Centre raised with us was different funding categories. So you've got to put a funding category against a particular service provision, but in some cases there'll be one lawyer who's a bit funded to do something from one funding pool, but also is funded from another funding pool. A client comes in and they want legal advice that some of which is from one program and some of which is from another, and how do you capture that as in terms of statistics? And that's for funding reporting reasons. So the National Data Standard is very clear. One session between a lawyer and a client, which is legal advice, it can be counted as one. Doesn't matter if there's 75 problems, 75 other parties, 75 legal issues. That captures, as I said, that creates difficulties in class. So the suggestion is that and again, what we're doing is making a solution that works for people using class, but also it works for people on the ground in how they've been doing legal practice, and then trying to meet the needs of the National Data Standards as a secondary issue, including talking to Data Standards Working Group. So our solution that we're putting forward is that centres a lot of centres are already doing it, but centres actually record the separate advices with separate other parties. What we will do at the back end is investigate a report that can pull them together, so that you, instead of having 5 different advices, it reports 1. We're still investigating that, so we're not 100% sure we can deliver on that. But I don't think it's too difficult. So we just take some time to get advice about at the back end of changing the reporting for class. So basically, the advice would be that you record separate legal advices for each problem type that involves different other parties. That sorts out your conflict check issue, and probably will resolve most of the issues. If there's still legal advice, same other parties, but you've got law areas that crosses over family, civil, criminal, then record them as separate legal advices. And if you need to record your advice against 2 different funding categories, then record them as separate legal advices. And then NACLC is looking into the back end to make sure that they meet the national data standards requirements. Okay, the other big issue for legal advice was a lot of people saying, or quite a few people saying, when I do a legal advice that involves quite a lot of time, so it might be researching the law or reading a lot of documents, I'm calling that a legal task because it's a lot of work. And one of the reasons they're doing that is because legal advice in class doesn't have a field to record time spent, and so that looked like a pretty quick fix to us. So that solution is we're going to put in. Some centres are still of the view that legal task is somehow in a hierarchy above legal advice, and that legal advice is like 1 or 2 hours, legal task is 5 or 6 hours. And I think that comes from the old Celsius way of looking at minor, medium, major tasks, cases rather. But we're very clear about a legal task, and I'll get to that in a moment, but the definition, it's not based on how much time you're spending or how complex the matter is, it's something different. So in terms of the difference between legal advice and legal task, we're very clear in the data consistency guide. We're saying it's not, if you're only researching reviewing clients' documents or researching the law to prepare legal advice, it's still legal advice, regardless of the length of time spent or complexity of the legal matters, so long as it does not involve any interaction with a third party or preparing documents for a client to use in legal proceedings. So that's because you'll see in a moment that's the definition for legal task. In class, these activities in preparing for the legal advice can be recorded as actions, and will have the ability to record time spent, which will help centres who want to be able to say, for example, to funding bodies, our average legal advice, we actually spend 2 hours on that because we're a specialist centre. We always have to review like a FOI file, or we're reviewing multiple pieces of legislation. So you can't compare our 150 legal advices per quarter to a centre that is churning through in 30-minute increments. And I think that's the important point centres wanted to make, is they need to be able to explain to funding bodies in particular that their legal advices are routinely more complex perhaps than others. So legal task was key issue number 5, and I think it's fair to say that legal task and ongoing legal support service, those 2 areas, so anything where it's working with a client who is self-representing through the system, were the areas of most confusion. The other issue is that class allows an end date for legal task, which people took as meaning, okay, it's kind of like a quasi casework service where I can open it and then close it, months down the track. So as a result, some centres were recording a whole lot of separate legal tasks with every interaction they might have on the matter with an external person. Some were recording new legal tasks if it was work undertaken on a different day. Another one, as I said earlier, some were opening a legal task in January and finishing it in November. So originally I put forward an idea that you would define legal tasks as being point in time or a moment in time, a short, so that the legal task would have the word somewhere in the definition, it's a short piece of work. Again, people pushed back and said no, because you end up getting down to, is it 3 hours, is it 5 hours, is it 1 day, is it over a week? So in fact, if there's a new definition of ongoing legal support service, that might take some of the messiness away out of having to define multiple legal tasks. But here's a definition of legal tasks that I've tested with a few people, and it seems to be clearer. So it's where a centre undertakes a discrete, clearly defined one-off piece of legal work to assist a service user in their own efforts to resolve a legal problem with no commitment to support the service user beyond the completion of that piece of work. So the 2 main types of work are reviewing or preparing particular documents for a service user to use in their legal proceedings, or a limited instance of interacting with a third party to help progress the service user's legal matter. It can include multiple activities, actions in class to finalise the piece of work. So I've tested that against a few case studies, and it seems to be an easier way. There seems to be much easier in saying, okay, that's one legal task, because up front you say, look, I'm just going to take your documents away. I can see they're court submissions. I'm going to review them and revise them for this and return them to you. But you're not saying to the client, I'm going to help you throughout your entire matter. Bring these back to me, you know, next set of documents, bring them back to me. You're just undertaking to do a small, discrete, clearly defined piece of work. Okay, I know you're all dying to ask questions, but I'm moving through to key issue 6. So court tribunal representation. So when a centre is acting for a client in a other rep matter, what do you do when the court or tribunal action starts? So some centres were saying you change the existing other rep service to court tribunal, and some were saying you close the existing other rep and open a new court tribunal rep service. I have to say the feedback I got on the data consistency guide was pretty even. Half and half really, some saying, oh yeah, do it this way, oh yeah, do it the other way. So we've got to pick one. And I think for me, and a lot of lawyers I spoke to, it kind of makes sense to close the other rep service and open a new court tribunal rep service. And it really helps if we clarify when you open a court tribunal representation service. And so the new definition, the revised definition in there is, it's where a centre provides ongoing representation for a matter that has commenced in a court tribunal inquiry. And commenced in this context means the matter has been filed in court, lodged in a tribunal, or accepted for inquiry by a forum such as a Royal Commission. So I think the vagueness was often around proceedings, like it's about legal proceedings, but what is that? Is that legal proceedings are gonna, you know, is legal proceedings a technical term? It's not really. So I think we're trying to make it clear that you open a court or tribunal representation service when a matter has been initiated in that forum. And it includes if you're about to initiate the matter. So if you know right now you're preparing the application and you're about to lodge, then you would open it because you're initiating the. And the data consistency guide provides a lot more detail. So this is just the top line heading, and then there's a lot of stuff underneath to step that out. So, but the rule we're saying is that you do close the other rep, and that the reason is that could have been open for months, weeks, months, or even a year. If it's an ongoing dispute with your landlord about repairs, for example, you intervene in the hope that you head it off without litigation. Once it gets to litigation, that's that second that you actually filed in the tribunal, for example, you do open another service. And I think that reflects on the ground how you run legal practices. Okay. So my timing is that I need to be at this point, tools and resources, almost there. So just to draw a breath and go, okay, is this going to change everything for my centre? You guys can tell me that better than I can tell you. But we do know not all centres do that much work with self-represented clients. Some centres have an advice and representation model. So not much is going to change for you. If you're not really helping people who are self-representing through the system, if you pretty much have, you do advice, and then if a client is in the eligibility criteria, you then act for them, you open a representation service, then this kind of new stuff about clarifying legal task and ongoing legal support service might not change how you record matters. Okay, so now we're up to tools and resources, and this is just what I'm going to do is explain to you what's going to be here to help you. So in a 1-hour webinar, I can't talk you through every single definition of every single service, but I want you to know that in about 10 days, so by the 31st of July, we should have up a whole lot of resources that together will help you understand the different service definitions. So some of them are familiar to you already. They came out with the data consistency guide. One is case studies. So we got some feedback to change and fix some of those, and we also got new case studies. That's going to take some time to continually put them up and update them, and we're very welcome people who have nutted through case studies in their own centre where they've had, volunteers say, or a new solicitor say, I've just done this, what is it? And you're welcome to flick us an email with a discussion of what a particular case that might have thrown up some questions for you. The Ready Reckoner, this was out with the data guide, and I did consult with a lot of national networks on this guide. This is this is just a snapshot of the front page, and it's being updated with feedback from people. What it does is it goes through, particularly for civil law, it's particularly useful, it goes through the main areas of civil law that community legal centres and family violence legal services practice in, and it gives you some examples of legal task, duty lawyer, non-legal support, discrete, ongoing, whatever, so that you can get familiarised with some common areas, and it's available as a Word document, so you can download it and delete the rows that are irrelevant to your centre, or do your own rows, and quite welcome to check in to see if you got it right. But some centres are using this already and are finding it quite useful. This is a new tool which just playing around with, and it's basically some questions came through in our consultation saying things, for example, if a service user gives us an authority to obtain information from a third party, doesn't that mean we're automatically acting for them? Aren't we automatically representing them? And I think it's really important to make it clear that no, that's something that you often do with clients when you're just finding out information for them. And it might be something that you do with non-legal clients as well. So there's a few other ones of those that came out where there was a category that allows you to differentiate between different types of services. So this is something that you might want to stare at for a long time and sort of think about if it helps explain things to you. Some people like these sorts of graphs because it helps explain. It might not be that useful for you, for other people. A flowchart, this is not quite ready, but we're doing a flowchart which is like a decision tree where it'll take people through, are you asking for the client's name? Are you doing this? Are you doing that? Is the person in court? And it basically steps you through and asks you questions and then says, if yes, this is a legal advice. If yes, this is a duty lawyer. If yes, whatever. So it's still a work in progress, and we hope that when it's available, you'll be able to download a version of it and take out limbs that are irrelevant to you. So fingers crossed we're going to be able to get it like that, but certainly that will be available soon. And finally, tools 5 and 6 are training. So this webinar, but also more webinars that actually take people through the data consistency guide, and the resources will come online through the class schedule of training. And the class help desk itself will be the place to turn to if you have questions. So James Oakby is on top of this stuff and getting increasingly on top of, I'm downloading my brain to him. So he'll be able to help you in the future, and the class help desk in general will help. There'll also be training at national conference and quarterlies. Need to talk to state peaks about that. Okay, so we're almost, I'm at the point of, I wanted to finish at 1:50. So what's next? So I've talked a lot about stuff we still have to do. So the revised data consistency guide I'm working on right now. It'll be, the one that's online at the moment will be changed, rewritten. It's, as I said, some areas big changes, other areas not so much. At the end of the page, I'm going to have a little note saying what changed between the March version and this version, just a quick summary. It'll be also available in Word and in PDF. All those resources being released. There'll be ongoing training and help desk support. The Data Standards Working Group, we are still talking to them about particularly saying that we're creating this new service. We're happy to map it back up to another service, but we want to know, if you guys think that it's a service that your services do. Discussion with funding bodies, we need to train the state and territory legal aid and Attorney General's departments about the data consistency guide and talk through those who have targets and require centres to report against certain targets. Obviously, there's going to be a change in some of your numbers if you've shifted from doing a lot of legal advices and tasks for one person on one legal issue. If you're now switching that into an ongoing legal support, then in making sure funding bodies are across what that might mean. And risk management guide. So it needs to be changed and edited to bring into line with data consistency guide, and need to consult with the National PAI network to talk through some of those tricky legal practice management issues. This is again the data consistency project timeline. So I just wanted to set out at the bottom there some just reassurance. The red is where we're up to now. So we've come through purple and pink, and now we're up to red, just in terms of what's up next. And yeah, and then we have, that's it. So that's my contact details. So just to learn, I'm finishing up on this project, but I am, as I said, staying in touch for expert advice. But the aim is that the other people at NACLC are going to take on that knowledge. But the data consistency guide and the resources pretty much will be the place to go to, with the backup support from the class help desk. And also we've got forums that we trialled during the feedback sessions, time period between March and May. No one used them, so we're going to rejig them and hopefully have a chance for people to get on there and talk about particular service types, so that it's a bit more interactive than just a one-way, someone emailing us and us emailing them. And if you've got a question, chances are other people do too. And that's all from me, Carly.
Cool, thank you so much, Polly. We've had a whole bunch of questions come through, so I might just start from the top, and we'll see how many we can get through before our time is up. So firstly, Giselle from Cairns has asked, if a legal and a non-legal worker both carry out the same activity, how would you record that?
Yeah, I've had a few people ask me this. It depends on the activity. So, for example, if someone from WA Kununurra, the Family Violence Legal Service, said if a solicitor was doing court support, but one day and then the next day a non-lawyer was doing court support, are they different things? And I think this crosses over into legal practice management, actually. So I would like to, if Giselle, if you have a specific example of the actual nature of the activity that they're doing, I think that's what's important. So I think in a representation or an ongoing legal support matter, you could have actions that were undertaken by people who were not lawyers. So you might have a paralegal drafting some stuff, or taking instructions to go, there might be some work that's being done. I think that's reasonably clear, and that's how lots of CLCs run their practices. But there are some areas that I think are a bit vaguer, and the one about court support, the difference between a lawyer being involved in a court support kind of program as opposed to a non-lawyer, it really depends on the type of activity. So Giselle, just shoot me through what the activity is, and I think that's going to help.
Yeah, okay, fantastic. So hopefully, Giselle, you heard that. She did have a follow-up part of the question, but I think you might have answered that. So it was really about what sort of non-legal worker it is, for example, a paralegal as opposed to a social worker. So Giselle, if you can send through your query to Polly, that might be helpful, and then it can be cleared up.
Can I just one thing on that. I think maybe it's about whether they're working in their specialist area as well. So for example, a financial counsellor. So I think send it through, and the text of the data consistency guide does talk a bit about this, so it might be resolved in there when it goes up.
Excellent. I've got Kylie next. So Kylie, I think, is from Rails. Hi, Kylie. So she's asked a couple of questions here. So firstly, can she access a Word or a PDF version of the National Data Consistency Guide?
Yes, as soon as I've finished revising it, it will be available as Word and PDF.
Okay, so maybe keep an eye out for that one. She was having some problems with the link. Secondly, is the Ready Reckoner a finalised document that they can rely on when making decisions about what a task is, or what is a task, etc., within their practice?
The version that's up there at the moment is about to be revised. So basically what's up there right now is all about to be revised. I can pop up the version that I'm working on pretty quickly, like by the end of this week.
All right, perfect.
If there's any questions when you look at the Ready Reckoner, if it doesn't ring true for you, then send us an email. But a lot of people have looked at the Ready Reckoner. So yes, the collective wisdom of the sector seems to be okay with it, but very happy if people say, hey, I don't think you're right on this one.
Okay. There are a few sub-questions which look like they're related to information services. Sorry, it's all come sort of through in one big block of text, so hopefully I don't miss anything here. If a client's booked an appointment for an initial advice but doesn't attend, is that initial phone call to get all their details to book in the appointment and information?
Yeah, so I think that's in class, there's a way of doing that as a triage, and then you can close it off as an information service, or yes, you could record it as an information service. There's a question there about legal practice management, about if they don't ever turn up and you give legal advice, do you want to retain their client details? So I think that might be an example that I'll put in the information services one, if you like. I think there's something in there in the revised text. So how about I make sure it covers off on that?
Great. With legal advice services, how many advices when the client contacts the service. So this is, I think, about accounting rule. So Rails provides the initial advice and then needs to review documents, etc., to provide further advice, and then contacts the client to provide that further advice on a subsequent date, or by phone. How many advices would that be?
I think that's just 2, it sounds like. So the clients comes in for the first appointment, and then is that what happens? And then
advice?
The CLC says, actually, yeah. And then the CLC goes away, does a bit more research, and then contacts them with additional advice. I mean, I think you'd say if the additional advice is exactly the same, then why would you contact them again? But if you contact them again because you've done further research and more information, I think that from a legal point of view, that's 2 separate instances of legal advice.
Yeah, I think I'd agree with that as well. So hopefully that is what you're doing, Kylie. Another, how many advices question. So if Rails provided initial advice by phone and then later decides that further advice or clarification is required, possibly due to instructions from their supervisor, is that 1 or is that 2?
This was actually discussed at Data Standards Working Group, and one snappy lawyer from a different sector said, oh, well, if you weren't good enough in providing your first legal advice that you had to go and get it checked and then correct it, it's still 1 legal advice. Again, I think this is a legal practice management question. If you think that the client would look at the second advice as being a separate piece of information, new information that they hadn't heard before, then you would record it as a second advice. But if it really is just the same advice with 1 or 2 things added and it's just a clarification, then you'd keep it in the same advice. One of the Queensland CLCs said that they have, I think Townsville or Cairns, Giselle probably could tell, has a rule where if it's the same worker, same day, so say same worker, same client, same legal issue, and within a few days, it's probably the same legal advice. But I think again, it's about, is the second advice new information? If there's new advice in there, rather than like a very short clarification of what you said the first time, then I think from a legal practice management point of view, they're 2 separate advices.
Yep, I think I tend to agree. For example, if it was a volunteer lawyer providing advice and you were checking the advices the next day as the principal lawyer and noticed that there was a limitation date missing or some other key part of information, and you phoned the client and provided that extra bit of information that is important but was missed the first go, I think that would just be the same advice. Is that what you reckon too, Polly?
I think so. I think the tricky bit is if it's the same lawyer ringing up a few days later.
Yes, that's true. Could be a different lawyer. So yeah, let's move on. But great questions, Kylie. Yeah. Different. So there's another bundle from Kylie. So they've got an evening clinic service for unrepresented asylum seekers. The clients attend the evening session. During that session, they work with the clients to complete an application form and a supporting stat deck to be submitted on their behalf, i.e. posted by Rails to the Department of Home Affairs. The appointments are limited to 3 hours in length. If they don't complete that work in 1 appointment, they finalise it in a 2nd or 3rd appointment. Is it appropriate to record each appointment as a legal task, as in each appointment documents are prepared for use by the client in relation to third parties, even though those documents might not necessarily be finalised in that appointment? They don't feel that they can record that as a file or an ongoing service, I presume, because they don't go on the record for the clients, they only submit the documents on their behalf.
I think it would be great if all the immigration and refugee legal centres together discuss this. I know RACs go back and forth with us about this. I think that if you say up front, the legal task is the review and revision of the documents and the very specific documents, then that is the task, and it may take 3 appointments to complete the task, but it's 1 legal task. If at each appointment there's a new set of documents and the centre says, okay, now I'm looking at a separate set of documents, then that's a different legal task. But if from the first appointment onwards you're very clear that the work you're doing is around just those documents, it doesn't matter if it takes 3 appointments to finalise the documents, that's one legal task. So the other thing that you could do, if you say to the client, I'm going to help you through this process, and it may be finalising the documents, but then there's another process after this and we're going to help you, then I think that's an upfront commitment, and therefore it's an ongoing legal support service, which is not representation, but it's a service where you're saying upfront, we're going to help you through these processes, as opposed to we're just going to help you with those documents.
Okay, hopefully that clears things up a little. Giselle has raised a good point here about secondary consultations. So has that been reconciled with the Risk Management Guide requirement not to provide advice to third parties? I know we were talking about this a little while ago, Holly, so I'm not sure whether you've resolved that in the meantime.
I did go and look at every single paragraph about this in the Risk Management Guide, and all of them are very clear in saying that it's information. If you're not speaking directly to the client, it has to be information service. And our solution is that it is an information service, that secondary consultations are a form of information service.
Okay, fantastic.
So that's in alignment.
Yeah. So Aaron from Townsville has some questions as well. One of the issues of introducing a new definition and mapping it against other representation is to do with targets. In Queensland, DJAG and LAQ recognised there were ongoing coming to grips issues with the national data standards a few years ago, and you know, in Queensland, we've been very lucky to have our targets varied where that has happened. However, they've had to have a variation to service agreements, which was a bit of a hassle. Given the 3-year funding cycles, Aaron's wondering about NACLC and CLC's Q's thoughts about future discussion with state program managers. It would make sense to open up the opportunity to resubmit targets in time for the new 3-year agreements, and in Queensland that is will be coming up soon. So Aaron's just wondering about what that might look like and how those discussions might roll. I'm not sure if you have a view on that, Holly.
I think I might handball that to you, Carly, because we did talk a bit about this, and I think it's a conversation between the state peak and the funding body about the fact that if it's introduced midway through a particular reporting period, then you're going to have a variation against targets. So that is a conversation that that I'd love to have with you and Legal Aid Queensland. But obviously, it's whatever works. And just to keep in mind, not all state government funding bodies are strict or even have targets. So it seems to be a big issue for WA, Queensland and New South Wales, which I think is most of the people on the phone. So it is a conversation that needs to be had to talk that through.
Yeah, so Aaron, we might take that one offline, but thank you for raising it, because I think it's important to have that chat, especially with the timing in Queensland for the next funding round. So Kylie has another question. In Queensland, we won't start using ongoing legal support as a category until that is negotiated further between the funders. Yes, I think that's probably right. I think, well, as Polly said, that it is still being mapped to other representation for the moment. So I think if it's available in class from the 1st of August, we can start using that because it will still be counted as other rep. Polly, is that your thought on that one?
Yeah, and there are some centres who are so desperate for it that we didn't want to say, oh no, let's all wait until every state government body is in alignment with agreeing. So that the important point is that although the service is available and you can use it, where we map it up to is a very simple back-end thing that NACLC can do. But we can also eventually map it up to itself so that it will be identifiable as its own distinct ongoing service. But yes, at the moment it does map up to other rep, which means that it's not putting you in breach of anything. It gets captured, basically. The counts will get captured in other rep.
Excellent. So you won't lose anything, and then we can have a look at that as a proper thing ongoingly in a little while. I've got a question also from Caroline. So we are getting close to time now, but it looks like we're on the home stretch for the questions. So thanks for hanging in there. So Caroline's asked, if I provide advice to a client and then draft a letter for them to send themselves, and they're self-representing, would they enter that as a legal advice and then a legal task as well? Or is it one or the other? So it's both legal advice and legal task.
Both.
Great.
Yes, and that's the Data Consistency Guide says it very clearly. that it'll say that it says it'll be both a legal advice and a legal task.
Excellent. Julie has asked whether, so in the circumstances where you might have one person ring over multiple times and they're sort of shopping for a different person within the centre and you keep referring them out, is that an information every time they ring and get referred out?
Yeah, it can be just a referral service on its own, or it could be an information and a referral. So one thing to remember with CLASS is that you can record it as either of those two things. Yep, just keep referring it out. Keep it in a, do the bulk entry, just make a mark on a hard copy bit of paper or whatever. Yes.
Excellent. And a last couple of questions from Jess in Mackay. Just clarification of what this situation might be counted as. So we've got a volunteer at an LAE provides advice, and then the following day an employed solicitor provides a missed limitation period to the client. So I think that's what we kind of raised before, Jess. So we've got here two separate people providing information to the client on two separate days. So is it one advice or two advices, I think would be the question.
If it's a different lawyer, it's two advices.
Beautiful. Last question. If a person calls to book an appointment and provides a brief summary of their matter, no referrals or information is provided by the centre, and then the client doesn't turn up for the appointment, is that just a triage or does it get changed into an information service?
So I think that if you're using CLASS for that, yes, it's a triage, and then you may as well capture a stat, which is to turn it into an information service. It's similar to the question that was asked, I think the third question.
Yeah.
So clearly two people want to know, so it's enough for me to step that out in a few lines in the guide just to clarify that.
Yeah, and quite a common scenario where clients are not showing up for their appointments, so I think that's a good to sort of make clear. Yeah. Yep. Usually you would be collecting quite a bit of information at that intake stage rather than just a name and phone number. You're probably going through details of their matter. I think that it would be right to capture that as an information. Okay, that's the last question. Does anyone else have any other questions? I'm hoping the answer is no, because Polly's done such a fantastic job of covering everything today. If you do have any further questions, though, please feel free to email them through to Polly or myself and I'll flick them over. And you can also contact James in the help desk at NACLC because he's just a wealth of information, particularly on the sort of technical class issues. Polly, is there anything else you wanted to let people know about today before we wrap it up?
No, just to stay tuned, and there'll be comms going out from NACLC about when all the revised guide, and so you can keep using the current guide. I will be getting the new, we'll have to be doing communications about the new service, so we need to time those, but that will happen in the next few weeks. And basically this is a taster. You guys are the first to hear the news hot off the press.
Excellent. All right. Thank you so much for all your questions, everyone. And thanks heaps, Polly, for tuning in and presenting all that information. We're looking forward to seeing the finalised stuff come through very shortly.
Thanks, Carly. Thanks, everyone.